Chapter 2 of Tractate Bava Kamma continues discussing the laws of damages. The first Mishnah says, the foot of an animal is muad, presumed to damage, meaning requiring a full payment if it damages by breaking things as it walks. If it kicked or pebbles shot out beneath its foot and it broke something, that's not muad, and it would require only half payment. If the animal steps on and breaks a utensil, and then the utensil falls onto a second utensil and breaks that also, the owner pays in full for the first and half for the second utensil. Chickens walking normally are muad also, meaning there would be a full repayment. If something was tied to its legs or it was hopping and that's how it broke something, the owner would pay half damages. The Gemara suggests the main case of the animal walking was the main category of walking, and the second cases were its subcategories. It argues seemingly contradictory wording from a later Mishnah, but that's explained to just be saying that a wild animal falls into the category of an animal. It further qualifies the particularities of the wording. We said damage via pebbles was a half payment, but others seem to debate this, saying it's a full payment, depending on the case. The one who says it's a full payment would hold that its force is like its own body, and the opinion that says it's a half payment agrees. They just hold it a half payment anyways, as it's a tradition from Mount Sinai. Additionally, some would hold if the contact between an animal and an object would be sufficient to make an object impure if contracted with a Zov impurity, damages would be paid in full, and that's relevant by the case of a cow pulling a wagon. It's also taught if there's a rope holding a bucket in place and chickens peck at the rope until it snaps and breaks the bucket, the chicken's owner is liable to pay in full. It's asked if an animal steps on the utensil and it doesn't break, instead it rolls a while and then breaks. Is this considered as if the animal broke it itself, or is it similar to the case of an animal stepping on a pebble? Some hold, based on a related case, that a utensil that breaks is considered broken from the beginning of the process. If further debates proofs on this, according to the opinion that the pebble damages are paid in half, it asks if the payment comes from the body of the animal, or if you can also put from his best property. It argues on this from a number of sources. This is debated further. Additionally, the situation of a pebble damage, it asks if this is considered to be muad, a likely presumed damage, or otherwise, based on other points, it's compared to the horn category or to the foot category. This is argued on. Also, it asks if the damage is considered abnormal. It could only be a quarter payment, so it asks if this applies to pebble damages, and it's unresolved. It's also unresolved as to the status of the force, according to one opinion. It further qualifies the wording of the Mishnah, and it's also unresolved as to if there's liability if the path is on such a manner that an ox just can't walk without kicking pebbles. It's also asked if the animal is in a public domain and it kicked pebbles. It's asked if this is comparable to the horn category, meaning the owner would be liable, or to the foot category, where it would be normal behavior and there would be no liability. It debates this. It also asks about the liability of an animal knocking items over via swinging its tail around, or another appendage, the latter of which is unresolved. Regarding things tied to a chicken's legs, he pays half if they got tied there by themselves. If he tied it, he would pay in full. This is said to be particularly if a person tripped over the item the chicken brought, which has a similar status to a pit. New Mishnah. The tooth of an animal is muad, presumed to damage and requiring full payment. If it eats things it would typically eat, so fruit and vegetables essentially. It pays half if it eats clothes or a utensil. This is if it's on the damaged person's property. If this is on public property, he would not be liable, and if the owner benefited from the food, he repays what he benefited. Payment is considered to be for benefit if the food is in the middle of the street or at the entrance of a store. It's for damage if it's on the side of the street or inside a store. The Gemara cites cases of what it's typical for animals to eat, discussing these instances. For instance, a goat once climbed up a barrel to eat a turnip and broke the barrel and turnip. The owner was obligated to pay for both in full, as it was deemed normal for the goat to do those things. Also, it's said if an animal is in public and eats food on the back of somebody else's animal, it's considered like the second person's domain and he's liable to repay. It argues on sources. If there's straw in a private domain and it rolls into a public domain, it debates the status of this item. It also argues on the definition of benefiting from the food. Some say it's a reference to the value of straw, some say it's referencing inexpensive barley. It debates related principles by domain boundaries and similar. These are further discussed along with a few particular incidents. In regards to the animal eating from the sides of the street, some say it means the animal turns its head to the side and eats. Others say it's exempt if it does this, and it refers specifically to being liable where it actually left the center of the street and walked to the side. If the concern is the animal turning its head to the side, the case of the animal eating from a storefront where there's only a payment of benefit and not damages must be where the animal didn't turn its head. So it must be where the street narrows like this, with a storefront staying in front of the animal. Others say the opinions agree there's liability for the animal turning its head, and they argue about if part of somebody's domain was made to be a public domain, one saying the animal is not liable for eating from there, others say it is. This would be unlike an actual pit or something within its category, as either you're not responsible for a pit in your property, but you also could not expect others to be liable for you leaving your fruits within your public domain. Or you could say a person is liable for a pit that's in his own public domain, but a pit is not visible, unlike fruits which are visible, and there would be no liability. If it argues on the dispute of an animal turning its head to eat, whether the payment is for benefit or for damages. New Mishnah. If a dog or a kid jumped off a roof and broke utensils that it landed on, the owner of the animal pays full damages, as it was muad, presumed damage here. If the dog took a biscuit with coals stuck to it and walked to some hay, and the hay caught fire, the owner must pay in full for the biscuit and half for the damage. The Kamma debates if this creates an implication there's no liability if the animal accidentally fell off of a roof. Some say it would be specifically liable if it was on a narrow wall. It argues this concept based on related cases. In regards to the animal causing a fire, some say it's liable as the fire is deemed his generated force, others say it's as the fire is his property. The debate is as whether fire is considered to be your force, or if it can even be property, as it has no substance. According to the opinion that the fire is his property, he'd have to hold that the coal was tossed at the hay, and then he's liable to pay half for the exact spot where the hay was hit, but not for the entire haystack. It debates these principles from other cases. There are additional cases quoted to try to disprove the opinion that fire is legally considered to be somebody's property. Additionally, the opinion that holds fire is somebody's responsibility as it's his force also holds it's his property too. So there's a practical difference between the opinions if a person was injured from the fire, if he needs to pay the 4 forms of compensation. Also, the case with the biscuit refers to where the coal was guarded and the owner of the dog must pay for the biscuit. Specifically, as the coal is guarded, it must be that the dog burrowed into the house. This teaches that a latch door is still legally considered to be burrowable through by a dog. Additionally, the dog brought the fire to the haystack that was also owned by the owner of the biscuit. This would mean that the mouth of an animal in somebody else's yard has the legal status of the person's yard. This has to be legally specified, as otherwise you could legally argue that his food shouldn't be in the mouth of your animal. So, the way that the tooth category of damage from an animal functions, specifically in reference to complete destruction, this could include the animal damaging by rubbing itself against a wall, say to totally erase an image, or by rolling over fruits and crushing them. It debates the principle by the status of the animal's mouth from related cases. It was additionally ruled goats in a market that cause damage, their owners are warned 2 or 3 times, and if they don't restrain them, the man's required to slaughter and sell the goats. New Mishnah. A muad animal, which is presumed to be dangerous and must have its payment for damages paid in full, is when it was testified that it had damaged on 3 separate days. It reverts back to its original status when it doesn't damage for 3 separate days. Others say it becomes muad if it was testified about 3 times, and it loses this status if a child pokes it in the head and it doesn't gore anybody. The Kamma explains the logic of this dispute is based on verses. These are further discussed. It rules based on the opinion that an animal becomes a muad when testified on 3 separate days, and it loses the status going back to being a tom, actually like the second opinion, when it's provoked without goring anybody. It also asks, does the muad status go on the ox or on the owner? This is relevant if 3 witnesses saw the ox gore on 3 separate days, but they all testified to the owner on the same day. It debates this from sources. Additionally, it's asked, what if somebody had another person's dog attack another person? The inciter would not be liable. So it's asked if the owner of the dog is liable based on if he should be responsible for having his dog be like that. It has a number of cases to try and prove either way. Either way, if the victim had incited the dog against himself, the owner is not liable, as that's considered to be an irregularity. New Mishnah. An ox that damages on the damaged party's property is where it gored, pushed, bit, squatted, or kicked. If he did this in the public domain, the owner pays half damages. If it did this on the damaged party's domain, it's debated if he pays full or half. The logic of paying full is that if it was a tooth or foot category damage, he pays half, so this is more stringent, so he'd pay full. The logic that he pays half is that he paid half by a public domain, so he should also here. They argue their logic further. The Gemara additionally debates the logic of these opinions from verses and similar. These principles are debated as to the different opinions, interpretation of verses. This is discussed. It's asked, according to these opinions, if an animal did a foot category of damage, stepping on a child in the damaged party's property, killing him, it debates as to the level of the repayment in such a situation, as the foot category is considered muad, something typically done, if it's comparable to the horn category of muad. It debates this and it says it would be comparable. New Mishnah. Anything a person does is considered to have the status of muad, whether intentional, unintentional, or if he's asleep or awake. If he blinds somebody or breaks something, he'd have to pay in full. The Gemara says, the grouping of damaging a utensil and somebody's eye teaches that if hurting the person was unintentional, he would not additionally pay the 4 forms of compensation for injury. Sources are cited. Similarly, for instance, if somebody was sitting with a rock on their lap and they did not realize it was there, and they stand and it falls on somebody, they would be liable for damages, but not for the 4 injury compensations. He also would not be liable for violating the Shabbos, and if he killed the man, he would not go into exile. And it's a dispute if the injured man was his slave, if he'd go free. If he was aware of the stone at first and then forgot about it and then stood, he is liable for damages and not the 4 compensations. He would be liable to go into exile based on a verse. He would not be liable for violating the Shabbos. And it's a dispute if the injured man was a slave, if he'd go free. If he meant to throw the stone only 2 cubits and it went 4, he'd be liable only for damages, not the 4 compensations. He would not be liable for Shabbos. He would not be liable for exile, and it's, again, a dispute by the slave. If he meant to throw it 4 cubits and it landed 8, he would be liable for damages, not the 4 compensations. He'd only be liable for violating Shabbos if he declared that it could land wherever it wanted. He's not liable for exile. And again, it's a dispute if it frees slaves. It's ruled if somebody throws a utensil off of a roof and somebody else smashes it with a stick before it hits the ground, the second man is not liable, as it's deemed as if it's already broken. Similarly, if somebody threw a utensil off a roof onto cushions and then somebody removed them before it hit the ground, the thrower is not liable. If somebody throws a child off of a roof and somebody else goes to catch the child with a sword, it's debated as to who's liable. It's also disputed who's liable if a muad ox caught the child on its horns. If somebody fell off of a roof and landed on a woman, accidentally cohabiting with her, he's liable for the 4 payments of compensation, and if it was a woman he needed to do yibum, the levirate marriage with, this is not a valid act of cohabitation. Specifically, he pays the 4 compensations of damage, pain, healing cost, and unemployment, but not for humiliation, the 5th payment here, as that's only paid if the damaging effect was intentional. Also, if somebody got blown off of a roof by an abnormally strong wind and he injures somebody, he's only liable for damages, but not for the 4 others. If it was a normal wind, he'd also be liable for the other compensations, but not for humiliation, as mentioned. If somebody places a hot coal on somebody's chest and the guy just left it there until he died, the placer is not liable for murder. If he put it on the man's clothes and it burned, he would be liable to repay, and it cites sources. It holds putting the coal on somebody's slave has the same legal status as putting it on the man's body, and putting it on the man's ox has the same status as putting it on his inanimate property. And that's the end of chapter 2.